background about the situation of migrant domestic work in the United States. So I'm going to do that. I'm also going to talk about, bring in towards the end of my remarks some comparative insights from some of the research I've been doing in Hong Kong, Philippines, Indonesia, and Taiwan. So I thought what I would do in terms of structuring the introduction to the situation in the United States is to just give you some background about the laws that apply to migrant domestic work or domestic work more generally, and then also give a sense of some developments that have happened very recently over the last, I'd say, 2 to 3 years. We've had some progress in addressing exploitation of migrant domestic workers, and I'll talk specifically about that. And then I'll turn to some remarks about the au pair program, which I think really needs to be brought into discussions about migrant domestic work and tends to be treated as a separate category. But I think some of the lessons we're learning from the au pair program bear on some of the problems with guest worker programs to bring in domestic workers in really critical ways. Okay, so just very briefly, the situation in the U.S. is much like the situation in many destination countries in terms of protections for migrant domestic workers. We don't actually have a guest worker program in the United States. It's very hard to come to the U.S. as a domestic worker. You basically have only 2 or 3 avenues, and they're very, very small avenues to come to the U.S. One is if you're accompanying a diplomat. Diplomats are allowed to bring domestic workers with them under what we refer to as A3 and G5 visas, depending on whether or not you're working for an embassy or if you're working for an international institution. The other way that you can come to that's the main way you can come to the U.S., actually. There are a couple of other exceptions. For instance, if you're a foreign national who's coming to the United States for a very limited amount of time, you may be able to bring a domestic worker, although that category is increasingly shrinking. So the situation of, despite these restrictions on migrant domestic workers coming in, we actually have a huge population of migrant domestic workers, largely undocumented. And so I think it's hard to get a good estimate on the numbers of domestic workers in the U.S. generally, but I think the range is around 220 to 250,000 domestic workers in the U.S. And, to the extent that you're coming in on a visa, your status is conditioned on your employment with a specific employer. So once you leave that employer, you're out of status and immediately deportable in the U.S. as a general matter, although, as I'll talk about, there is an exception now. Now, in terms of, once you're in the U.S., domestic workers are explicitly excluded from our laws that guarantee the right to organize. Domestic workers are explicitly excluded from the right to overtime pay if they are live-in domestic workers. They're functionally excluded from occupational safety hazard protections, sexual harassment protections, because those 2 laws require an employer who employs a much larger number of employees, which is not the case in households. So they're functionally excluded from those protections. Technically, our Department of Labor Wage and Hour Division, so what I will say is that they are entitled to minimum wage for every hour worked. Not overtime pay, but minimum wage for every hour worked. And that law is under our Fair Labor Standards Act, and that applies actually to undocumented workers as well. So that's a good thing. But in practice, in order to claim protection to or remedies in the case of violation of failure to pay minimum wage, it requires that a worker file a complaint. And so it's complaint driven. It's not as the Irish system, has shown us. It's not a system where labor inspectors proactively go into households to investigate whether or not there's been compliance with labor laws. It's based on the worker actually stepping forward to complain, which for a variety of reasons domestic workers who are exploited don't, right? Whether it be out of loyalty to the family, love for the children, concern about whatever coercive circumstances she may be working under, It's also not a mechanism that is obvious. It's actually hard to figure out who to call, who to approach in order to get a labor inspector in. And as a general matter, labor inspectors, to the extent that they are called, they're generally very uncomfortable with the idea of entering a household, not surprisingly, out of concern for violating privacy issues, but also at least as has been explained to me, one of the main reasons for the reluctance to enter into households is that these cases are very hard to prove. They end up being a he said, she said sort of scenario where it's very hard to make a determination as to what actually happened, and whether or not there's a valid claim. So the end result is, in the U.S., most domestic workers, again, we don't have great statistics on this, but the general consensus is that most domestic workers are undocumented and effectively beyond the reach of labor law because of the way in which labor law is structured to be worker complaint driven, right? Those protections are only triggered if a worker comes forward. Now, in terms of public attention to the situation of domestic workers in the U.S., there have been two developments that have increased attention, raised public awareness about the tremendous levels of exploitation occurring in the household, in the employment of these workers. Those two are one, trafficking. The trafficking movement has shown a spotlight on the situation, particularly trafficking by diplomats in the U.S. So in New York City and Washington, D.C., where I'm from, we have many cases involving trafficking by diplomats, trafficking of domestic workers by diplomats. And this was an issue that was first, I think, exposed by Human Rights Watch way back in 2001. And it wasn't until 2008 in the U.S. that we actually had laws that tried to address this situation of diplomatic trafficking. And it took a great deal of advocacy to even get to that point. And the main problem is, as you can imagine, that diplomats have very broad immunity from prosecution, civil and criminal prosecution. And so the types and the laws that the law that we've passed in order to address the situation is in the context of our anti-trafficking law, the reauthorization of the U.S. trafficking law in 2008. And basically all that law does and can do is to provide administrative measures to try to prevent trafficking, right? There was no possibility of making a declaration that diplomatic immunity doesn't apply. I mean, there's no way really to undercut the basic diplomatic immunity the right to immunity that diplomats have. So the best that we can do is try to create preventive measures. And so in this law, what we try to do is, put in administrative requirements so that the diplomatic missions have to assume responsibility for the fact that their employees are employing domestic workers, because it used to be the case that where there was a complaint about diplomatic trafficking, the chief of the mission would say, well, I don't know who our employers are hiring, we don't keep track of these things. And so basically they put in these administrative requirements where there has to be a contract on file, there has to be registration of a worker. Until this law was passed, there was no accounting whatsoever of the number of domestic workers that had been brought into the U.S. under these visas. And so the mission chiefs have to keep track of the visas. Employers of domestic workers have to show that they are financially able to hire a domestic worker. They have to set up electronic payment systems, so the workers have to be paid electronically. So there are a number of requirements that they've put in place. One of the strongest provisions that we succeeded in getting into the law was that a provision that requires the State Department Protocol Office, which is the office that deals in our State Department that deals with the different embassies, and there's a requirement that the Protocol Office suspend the issuance of these visas, these domestic worker visas, in cases where there have been credible cases of exploitation by mission staff, right? Or embassy staff. And so if you have a credible case, technically the protocol office should suspend issuance of these visas to anybody in that mission. So it just takes one person in a mission to have exploited a domestic worker in order to trigger that suspension requirement. That suspension requirement has never actually been implemented, and the protocol office, despite it being part of the law, the protocol office refuses to actually come up with standards for suspension, and their argument is, look, we are the State Department, we're not a Labor Department. We do not have the capacity to investigate these cases. This is not our area of expertise. We can't possibly be in the position to judge whether or not suspension is appropriate. And so it continues to be a point of contention between the advocacy community and the State Department to try to get them to actually enforce this part of the law, which they've been very resistant to do. Now, one development that is encouraging is that a few years ago, we did manage to get a regulation in place that basically affords A3G5 workers the right to stay. Even after they leave the exploitative situation, they have the right to stay in order to bring a complaint based on a trafficking claim or some sort of labor exploitation claim. So that was actually extraordinary because, in terms of remedies available to people who have trafficked, we have a trafficking visa. So people who, can show that they have been trafficked, contingent on their cooperation with criminal prosecution, they can actually apply for a visa to stay. But what's great about this remedy is that it's not limited to trafficking. It's broadened out so that it actually covers other sorts of labor exploitation. And this one measure is one that domestic workers' rights advocates are trying to replicate in other contexts outside of the diplomatic trafficking context. Now, whether or not they'd be successful in doing that is one can be skeptical that they would be successful because the population of A3G5 workers is only about 2,000 to 3,000 workers in the U.S., so a very, very small percentage of the domestic workers in the U.S. Nonetheless, the fact that they were able to get that right for those workers opens the door slightly. Another encouraging development is that in the U.S. case law, there's a recent case that basically limits diplomatic immunity for non-sitting diplomats, right? So it limits the residual immunity. So once you have a diplomat that's left that position, you can sue that diplomat. Now, the main question is whether or not, you can still fall, the case can still fall within the statute of limitations. So that the timing is always tricky. But if you have a case where a diplomat is no longer a sitting diplomat, you can sue. Because the determination by this court was that the residual immunity that a non-sitting diplomat has is limited only to the official acts of that diplomat in the course of their duties, and so it doesn't extend to the domestic worker relationship, employer relationship. So those are two encouraging developments in the case law and in the legislation. And like I said, trafficking, the situation of trafficking and media stories about trafficking, particularly by diplomats, really raise the profile of the situation of migrant domestic workers in the U.S. Another reason for the attention is over the last 2 years in particular, in addition to the ILO Domestic Worker Convention, is the fact that we have reached the point where our baby boomer generation is starting to become elderly. And so domestic workers' rights advocates have latched on to this demographic shift to raise attention to the important role of domestic workers, because what we were finding, what the advocacy organizations and domestic workers' rights organizations were finding, was that more and more domestic workers who are taking care of children are now also taking care of the elderly individuals in the family. And so they have seized upon this demographic shift, right, the baby boomer generation aging out, to raise attention to the role of domestic workers in elder care. And so there is a campaign known as Caring Across Generations that was launched last year to really raise the profile of the situation of domestic workers in the elder care context. They hadn't been successful in getting attention to domestic workers providing child care, but because of the baby boomer generation shift, And also, strategically, the elderly population is a voting population, right? So they can actually get political traction by focusing on elder care in particular to try to bring reforms. And so some of the questions that we're facing in the U.S., questions that we continue to struggle with are, do we create a guest worker program? And the domestic workers' rights organizations really don't want to create a guest worker program. What they would prefer to do is to take that huge population of undocumented domestic workers who are already providing care, to find a way to regularize them and provide them with a professional sort of career ladder. And they would have to, complete coursework and get sufficient training in order to get that right to stay in the U.S. So that's an ongoing advocacy project. But part of that project is, and I'll just say very quickly about the au pair program, one of the concerns that advocates are facing is the role of the au pair program, which has grown tremendously since its inception. When it first was created in the early 1990s, it was only 2,000 au pairs. It is now 23,000 au pairs in the U.S. That's about 10% of the domestic worker population. And the au pair category is not treated as a labor force. Technically they're in an employment relationship, and our Department of Labor has recognized that. But despite that finding, the au pair program is considered a cultural exchange program. And so the oversight is held by the State Department, not the Labor Department. And again, the State Department says it has no expertise and ability to oversee a labor program, so it doesn't. It basically allows for au pair agencies to engage in self-reporting of their compliance. We actually, unlike many European countries, we actually do have very explicit regulations, detailed regulations regarding the au pair program, but they're not actually implemented because of this self-monitoring system. And our au pair program actually has longer working hours, probably the longest working hours in the world, right? So au pairs can work up to 45 hours a week. And they're paid at minimum wage minus 40% for room and board, right? So they're making about half of minimum wage, and the growth of this population and the way that they've been treated, because the fact that they are an official State Department program has shielded them from scrutiny until migrant domestic workers' rights or domestic workers' rights organizations haven't been partnering with au pairs. I mean, they too view them as a separate category, and only over the last year has the domestic workers' rights community started to see the value in aligning with the au pair population, and also, out of a recognition that they too are domestic workers. They're just not officially recognized as domestic workers. And so now there is a movement to try to bring these two communities together and to advocate on behalf of all domestic workers, including au pairs. But the au pair example also, the problems that we have with the au pair program really bring to bear questions about the role of recruitment agencies. And I think, Jean talked about, the importance of going after recruitment agencies, because it's very hard to create laws that actually target the exploitative recruitment practices. The recruitment agencies always seem to be one step ahead, and we see this in Hong Kong, a country where there are very strong labor law protections for domestic workers, but they're effectively completely undermined by the fact that the recruitment practices are not actually regulated in any meaningful way. Technically, there's a limitation on the amount of debt that a worker can carry in coming into Hong Kong, but that's not implemented in any way. And so it creates situations of potential debt bondage that are escape the scope of even an extremely, relatively protective domestic worker law in Hong Kong. So I think my time is probably up. And so I'll stop there, but if you have any questions about anything that I've said, I'm happy to expand. Thanks.